There we go. There's ghosts in the machine this morning. Good morning. Happy Friday. Welcome to the Courtroom Files live. Live and a bit messy, but that's okay. I've already had to replace equipment this morning. We're going to start off in Bexar County. This is that jail court that we started watching yesterday, so we're going to start there again today. Lots going on, more to say as people move in.
Yes, sir.
I'm now looking at a document on my screen entitled Trial Court Certification of Defendant's Right of Appeal. You signed it and your attorney signed it. When you signed this document, what you did in effect was you told me, Judge, I understand that if my attorney makes a plea bargain agreement for me with the prosecutor, if you follow that plea bargain, I understand I will not have a right to appeal. Do you understand that, sir?
Yes, sir.
So then, to the offense of criminal trespass, how do you plead? Guilty, not guilty, or no contest?
No contest.
You understand on a plea of no contest, the court can still find you guilty.
Yes, sir.
Has anybody forced you to do this?
No, sir.
Besides the plea bargain, that's your lower gap for you. Besides that, has somebody promised you something in order to get you to do this?
No, sir.
Are you entering your plea of your own free will?
Yes, sir.
Is there a plea bargain? Can I ask the state to please recite it if there is?
Yes, Judge. We're asking for a $0 fine, court costs, 30 days in the Bexar County Jail, credit for time served, and time and money to run concurrent. And he has 20 actual days.
Okay, now I'm going to judgment satisfy it. Do you agree to this plea bargain then, Ms. Sparks?
Yes, Judge, we were just gonna ask to judgment satisfy him with the 20 days.
And I am going to do that. So do you agree to this, Mr. Molina?
Yes, sir.
And Mr. Molina, the court having heard you plead no contest. On that plea, the court finds you guilty. I follow the plea bargain. I sentence you to a $0 fine plus court costs. I sentence you to 30 days in the Bexar County Jail. I give you credit for time served, time and money run current, and the judgment is satisfied. Do you know if this is the only case holding your client, Sparks?
It's the only one I'm aware of, Judge.
If this is the only case holding you, sir, then you should be released sometime today. All right?
All right.
Good luck to you. Tell the deputies that we are finishing your case, and Ms. Parks, you can be excused. Thank you.
All right. Thank you.
Thank you, Judge.
Okay. One down, a million more to go. So what do we got next on the hit parade here?
Thank you.
Okay, who do we have on the bench? Pardon me? Did you
Marshall for Attorney Hernandez.
Got it. Yeah, we're done.
Hold on, let me see. Mr. Vale, I'm looking for your name on my docket. What is that Mr. Padilla?
That is, Judge. That's my client.
Right.
All I had to do is find them.
Found him on my paper docket. Now I gotta find him on my screen. Come on. All right, Padilla. Okay, Mr. Padilla, can you raise your right hand for me? Can you raise your right hand? Do you swear the testimony you're about to give me will be the truth, the whole truth, nothing but the truth, so help you God? Sir, do you swear the testimony you're about to give me will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Put your hand down. Put your hand down now. Let me share my screen. Okay, do you see the screen? Padilla, do you see the screen? Mr. Padilla, I need a yes or no answer to the questions I'm asking you. If you can't hear me, then let me know you can't hear me. Do you see the screen, sir?
Yes, yes, sir. I do.
Okay. Is your name Sergio Padilla Jr.?
Yes.
Are you the same
Yeah.
Sergio Padilla who in this cause number CC
Consider my reaction for 40
6538 who is charged with the offense of failure to
Force.
identify? Is that you?
Not in favor. A reminder, I can't get this paper on time.
Let me do this again. I need a yes or no answer to the questions I'm asking you, sir. Okay?
Yes,
Pay
it
attention.
is.
Please pay attention. Are you the same Sergio Padilla who in this cause number CC 716538 who's charged with the offense of failure to identify? Is that you?
I came on the 25th and you weren't here.
Okay, Mr. Padilla, I need you to pay attention, all right? I just asked you if you're the same person in this case who is charged with this offense of failure to identify. Is that you or not you?
I just turned in my papers, sir.
Now, I didn't ask you if you turned in your papers. Mr. Vale?
You.
Do you need to go back in the room and talk to your client some more?
Thank you.
Mr. Vale, I can't hear you.
That's last minute here.
He's been very slow, Judge. I've gone over the paperwork with him several times. It may be better that we refer him back to the court so I can.
Yeah, because if he's not going to be responsive, I'm not going to spend the whole morning.
Correct.
I got other people waiting. All right. Okay, Ramirez, send Mr. Padilla back.
You wouldn't see much. Yeah, Judge.
Okay, sorry.
Thank you, Judge.
I'm sorry, Mr. Vale.
That's okay, Judge. I mean, we'll work with him. We'll just get him back over to the court. I'll let them know. We'll get it in next week.
Okay.
Thanks, Judge.
Okay, I'm gonna go back. And Mr. Padilla, I'm going to trash his paperwork. Okay. Is it the end of the week? Or am I just being impatient? Maybe I'm being impatient. Okay. Who is next on the hit parade here? Is anyone next?
Judge, Attorney Cranberg for man on the 3rd page.
Okay, hold on. Let me go to my screen. Okay, I've got here Christopher Mann. I got his paperwork on my screen. Okay.
Yes, sir.
Okay, Mr. Mann, can you raise your right hand for me? How about your other right hand?
Sorry about that.
You swear the testimony you're about to give me will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you. Put your hand down. I am about to share my screen with you. Okay, do you see the screen?
Yes, sir.
Is your name Christopher Mann?
Yes, sir.
Are you the same Christopher Mann who in this cause number 2025 CC 006149 who is charged with the offense of evading arrest? Is that you?
It's here in San Antonio, yes.
Okay, this is my question. Are
Yes.
you the same
Yes.
person who in this cause number is charged with the offense of evading arrest? Is that you?
Yes, sir.
Evading arrest is a Class B misdemeanor, and it's possible in your case that you could be punished anywhere from a minimum of 0 days in jail up to 6 months in jail. In addition, there's a fine possible anywhere from a minimum of $0 up to $2,000. Do you understand what you are charged with and what the possible punishment could be in your case, sir?
Yes, sir.
I'm looking now at a document that's entitled Defendant's Consent to Plea by Video. And you have signed it. And your attorney has signed it. When you signed this document, what you did was you told me, in effect, Judge, actually, that it's okay with you that we do this by video, that we don't do this in open court. Is that correct?
Yes, sir.
I'm looking now at a document entitled Defendant's Waiver of Constitutional Rights. And you have signed it and your attorney has signed it. Did you go over this document with your attorney?
Yes.
Did your attorney explain this document to you?
Yes.
And do you understand it?
Yes.
Hold on, let me sign this document. Are you a citizen of the United States?
Yes.
I'm now looking on my docket on my screen at a document entitled Trial Court Certification of Defendant's Right of Appeal. And you signed it and your attorney signed it. When you signed this document, what you did in effect was you told me, Judge, I understand that if my attorney makes a plea bargain agreement for me with the prosecutor, if you follow that plea bargain, I understand I will not have a right to appeal. Do you understand that, sir?
Yes, sir.
So then, to the offense of evading arrest, how do you plead? Guilty, not guilty, or no contest?
No contest.
Okay, hold on 1 minute. You understand that on a plea of no contest, the court can still find you guilty.
Yes, sir.
Has anybody forced you to do this?
No, sir.
Besides the plea bargain that your lawyer got for you, besides that, has somebody promised you something in order to get you to do this?
No, sir.
Are you entering your plea of your own free will?
Yes, sir.
Is there a plea bargain? Can I ask the state to please recite it?
Yes, Judge, we're asking for a $0 fine, court costs, 23 days in the Bexar County Jail, credit for time served, time and money to run concurrent, and we ask that this case be, we ask that the judgment be satisfied per the felony agreement.
Is that your understanding of the plea bargain in this case, Ms. Cranberg?
It is, Your Honor.
You agree with this, Mr. Mann?
Yes, sir.
Then, Mr. Mann, the court having heard you plead no contest, on that plea, the court finds you guilty. I follow the plea bargain. I sentence you to a $0 fine plus court costs. I sentence you to 23 days in the Bexar County Jail. I'll give you credit for time served, time and money to run current, and the judgment is satisfied. Do you know if this is the only case holding your client, Ms. Cranberg?
He signed for prison time yesterday, Judge, so he was just resolving this case so that he could catch Chain. Oh, and I think he has a warrant out of Frio as well, so he will not be released.
Okay, so this case will no longer hold you, but if you have any of the warrants out there, they will hold you, okay? You
Yes, sir.
that?
Yes, sir.
Good luck to you. Tell the deputies that we're finished with your case, and Ms. Cranberg, you can be excused. Thank you.
Thank you, Judge. Y'all have a good one.
You too.
All right, good morning again. Excuse me. Good morning again, everybody. Welcome to the Courtroom Files Live. Happy Friday. We're going to make lemonade out of lemons again today. Just like yesterday, the majority of judges that we would normally follow will not be in, but I've got some things queued up that happened after the live show yesterday that we can look at. Judge Boyd has just opened up her court a little while ago, so we'll see what's going on there. We were just watching, and we'll go back to the Bexar County Jail Court, which is something that we picked up yesterday that was kind of interesting. When you see the paperwork on the screen with him, we actually get to see how the sausage is made, which is kind of unique because I haven't seen anybody else do that. And they're not giving away addresses or anything, so I don't feel too concerned about privacy issues there or anything like that. So lots to say, lots going on today, but we need to talk about Judge Fleischer for a minute. I did a little lurking yesterday and today, and it would appear that he has completely pulled the plug now on his live stream, and I don't know if we'll be seeing him again. It looks like he came under pressure from the Harris County Criminal Lawyers Association, filing complaints against him. And, you know, I like Judge Fleischer a lot. I mean, he's entertaining. I think he's fair, all of those things. He also never struck me as somebody who would stand up well under pressure necessarily, and I think the pressure just probably became too much for him. So unfortunately for a lot of law tube out there who were very Judge Fleischer focused, they're going to have some problems going forward and have to rethink what they do. Luckily here, Judge Fleischer was always a part of what we've done, but it's been far and away from the only thing that we've done. We follow a lot of judges because I want to see a lot of different law. I want to see a lot of different ways that things are done so that we can learn. Judge Fleischer's great for drama. He's great for entertainment. But there are other places where we can learn and watch law and stuff like that. So that's what we're going to do now. Maybe he'll come back at some point. I'm not going to hold my breath. We'll see. I kind of feel bad for him in a way. I think the guy definitely wants to make changes, but I think he's in a tough area to do it. And unfortunately, too, when you stand out from the crowd too much, that often tends to be when you get slapped back the most. And just from the way he acts and the way he dresses and everything else, not criticism, just fact, he stands out from the crowd. And that gets you slapped back hard if you're not careful. So that's where that's at until further notice, or probably ever. No more Judge Fleischer. Apologies to channel members because one of the things that we gave you there was his daily docket. But I do have a backlog of his older dockets that I'm going to attempt to get up for you guys, and we'll see what we can do there. But show goes on. Show moves forward. We're building a nice community here, and you know, every time a door closes, many more open. So we'll find more judges that are better, because that's what we do. All right, so with that having been said, let's go back to this jail court as I continue to piece together the day, but this is a good place for us to be at the moment.
Okay, so Mr. Wilson with the DA. Mr. Wilson, what's happening with your case?
Judge, I think this setting is a little premature. My client has picked up a new felony that there haven't even been an attorney assigned for the DA's office. And
So we have a felony pending, so that correct, basically?
Correct.
Okay, thanks, Wilson.
Thank you.
You can be used. Thanks for that. Okay. Let's see what my breakout was at. I'm waiting for the DA to finish talking to Mr. Collins. And then after that, I'll be ready to take that plea that's on the screen. Ms. Calderola, I'm assuming you're in line to take a plea. Is that right?
That's correct, Your Honor.
Okay. Sorry, we'll get to you as fast as we can.
It's Friday.
I know. Either things go really well or really bad on Fridays. It's not together.
Deborah? You're there?
Yes, I'm here.
I think the paperwork was sent under the wrong inmate. It looks like what I got was under a Goldsboro, which is...
No, Goldsboro isn't scheduled until Monday, I believe.
Yeah, so maybe did you send one on?
Your client today is Wendell.
Right, but I don't think I got that paperwork.
Yeah, I sent you a reminder on Wendell this morning. Maybe refresh your screen. I saw you did Goldsberg paperwork. I saw that.
Yeah, that's the one.
But you haven't done Wendell's yet. And I sent you a reminder on Wendell this morning.
No brownie points for doing something ahead of time, Mr. Brett.
I can send it a reminder again.
Yeah, if you wouldn't mind, that's the one I'm having trouble finding.
I just sent you a reminder again.
Okay, thank you.
You're welcome.
Okay, so then I've got the DA. Let me see. I have Mr. Marshall's paperwork on my screen. And let's see, Mr. Hernandez, is you ready to go on the plea?
Yes, sir.
Okay, so Mr. Marshall, can you raise your right hand, please? Do you swear the testimony you're about to give me will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Thank you. Put your hand down. I'm about to share my screen with you. Okay, do you see the screen, sir?
Yes, sir.
Is your name Dwayne Marshall?
Yes, sir.
Be the same Dwayne Marshall who in this cause number 2025 CC 005945, who is charged with the offense of theft of property of something having a value between $100 and $750. Is that you?
Yes, sir.
This case is a Class B misdemeanor. It's possible in your case you can be punished anywhere from a minimum of 0 days in jail up to 6 months in jail. In addition, there's a fine possible anywhere from $0 up to $2,000. Do you understand what you are charged with and what the possible punishment could be in your case?
Yes, sir.
I'm looking now at a document entitled Defendant's Consent to Plea by Video that you signed and that your attorney signed. When you signed this document, you told me that it was okay to do this by video. We don't have to do this in open court. Is that right?
Yes, sir.
I'm now looking at a document entitled Defendant's Waiver of Constitutional Rights. And you have signed it and your attorney has signed it. Did you go over this document with your attorney?
Yes, sir.
Did your attorney explain this document to you?
Yes, sir.
And do you understand it?
Yes, sir.
Hold on, let me sign this document. Are you a citizen of the United States?
Yes, sir.
I'm looking at a document entitled Trial Court Certification of Defendant's Right of Appeal. You signed this document, so is your attorney. When you signed this document, what you did was you told me, Judge, I understand that if my attorney makes a plea bargain for me with the prosecutor, if you follow that plea bargain, I understand I will not have a right to appeal. Do you understand that, sir?
Yes, sir.
So then, to the offense of theft as a Class B misdemeanor, how do you plead? Guilty, not guilty, or no contest?
Guilty, sir.
Excuse me?
Guilty?
Okay. Has anybody forced you to enter this plea?
No, sir.
Besides the plea bargain that your lawyer got for you, besides that, anyone promised you something in order to get you to do this?
No, sir.
Are you entering your plea of your own free will?
Yes, sir.
Is there a plea bargain? Can I ask the state to please decide it if there is?
Yes, Judge, we're asking for a $0 fine, court costs, 30 days in the Bexar County Jail, credit for time served, and time and money to run concurrent, and he has 27 actual days.
Okay. I'm going to judgment satisfied. So do you agree to the plea bargain, Mr. Hernandez?
Yes, Your Honor.
And do you agree to this, Mr. Marshall?
Yes, sir.
And Mr. Marshall, the court having heard you plead guilty, on that plea, the court finds you guilty. I follow the plea bargain. I sentence you to a $0 fine plus court costs, sentence you to 30 days in the Bexar County Jail. I give you credit for the time served, the time and the money run current, and the judgment is satisfied. Do you know if this is the only case holding your client, Mr. Hernandez?
It is, Your Honor.
If this is the only case holding you, sir, then you should be released sometime today. All right?
Yes, sir.
Good luck to you. Tell the deputies that we're finished with your case, and Mr. Hernandez, you can be excused. Thank you.
Thank you, Judge. Have a good weekend.
Thank you. Have a good day.
Yeah, Ashley, I would agree. Hopefully it does help his mental health. The one thing I will tell you is when you are public facing, and obviously I have experience with that, you have to have just an iron will and not particularly care what anybody thinks or what anybody says. You care, but I think you know what I mean. You have to take the compliments and take those in stride, but you also have to have this iron shield up against those who want to tear you down, and not everybody is necessarily built for that. And I wonder, and I've wondered for a while, honestly, if Judge Fleischer was one who was really built for that, to have that much notoriety and be that much public facing and be able to withstand the scrutiny. I don't know. This is just me speculating. Obviously, I don't know the man, so who knows? Let's do this. I have Judge Mogan from Burnett County, Wisconsin. This is from yesterday. And we didn't get to see it because she came on after our live stream, but let's spend a little bit of time with her because we've seen her the last couple of weeks and we've enjoyed her court. So let's go there for a while.
Face.
All right, I have two people in custody. I have Miss Newman, and that looks like Miss Chamberlain, maybe? Miss Chamberlain? Okay, thank you. I'm waiting for Miss Landgraf. I do have a telephone 320, starting with 320. Who is that?
Rebecca Baker.
I can't hear you. Who?
Rebecca Baker. Hello.
All right, everybody just wait. Okay.
And Judge, we have 4 at 2, so once these 2 are done, I will replace the other 2.
That sounds great. Who's the other one in custody? I can't see them.
Mrs. Barbara Bandis.
Vicky, thank you for the $2. Very much appreciated. All of you are very kind to me. Again, as I mentioned yesterday, that sort of thing does not go unnoticed. It's very much appreciated, so thank you.
So we'll do Miss Chamberlain first. Oh, but we can't because we don't have Miss Landgraf.
You want to do her and I'll go and mute her quick?
I can do Miss Vadness.
Okay.
If I can see her, but it's the video.
Yep, I'll go and mute her. Yep, she
Okay,
can't touch it.
sounds good. Who is youth? Who came in as youth?
This is Darren Dennison. I'm using a computer in a like a youth building.
Okay. So you're Darren. Oh, Darren Dennison. Darren Dennison. Okay, and Rebecca Baker, Nicholas, and Daniel Chapman. Chapman, whose cases are you on?
I just have Ms. Vadness, Judge.
Okay, excellent. I didn't know she had an attorney. We will go on the record in the matter 25 CF62, State of Wisconsin versus Barbara Vadness. The state appears through District Attorney Kevin Schmidt in person. We have Ms. Vadness appearing by video conferencing in custody in Burnett County Jail. Her counsel, Daniel Chapman, appears by video. We're set today in this matter for an initial appearance. Mr. Chapman, were you able to go over the criminal complaint with Ms. Vadness?
I was, Your Honor.
She understands charges and maximum penalties.
She does. We will waive reading of the complaint.
Is she still on West Rivers, or are you still on West Reservation Road?
Yes.
And telephone, do you have a telephone number?
Yes. It's 715-919-2502.
May we send you text message notifications if we need to?
Yes.
Preliminary hearing within time limits or outside, Mr. Chapman?
She's actually prepared to waive that outright, Judge.
Okay, so Ms. Vadness, did your attorney go over with you what it is to have a preliminary hearing?
Yes.
And you understand that the state has the burden to prove a felony was probably committed by you in Burnett County?
That's correct.
Do you understand that your attorney would have the ability to ask questions of the state's witnesses or call witnesses to testify for you, but you're giving up that right today?
Yes.
You understand that your attorney could possibly discover things about the case, which could include defenses, but you're giving up that right today?
Correct.
Do you understand that if the state does not meet its burden, I could amend the felony to a misdemeanor or dismiss it altogether, but you're giving up that right today?
Yes.
Do you understand that as a result of waiving your right to a preliminary hearing, this matter will be bound over to future proceedings, which could include a trial?
Yes.
Has anyone made any threats or any promises to you to have you waive your right to a preliminary hearing?
No.
You're doing so freely, intelligently, and voluntarily?
Yes.
And do you understand that once you waive it, it is forever and you can't get it back?
Correct.
I will find that you are competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and bind the matter over. Information, Mr. Schmidt?
I hadn't actually discussed the arraignment with Miss Vadness yet, Judge. If we could just schedule that, please.
We certainly can. We can do your May 12th at 9.
That looks fine, Judge.
May 12th at 9, we'll have an arraignment. Thank you. We are adjourned.
Thank you, Judge. Have a good day.
You too. I wonder if Miss Landgraf knows that she is your counsel, Miss Chamberlain, or who is this? Is Miss Newman?
Yep, I got Miss Newman here, okay?
Thank you. And there's Mr. White.
Yep.
We will go on the record in the matters 25 CF 57, State of Wisconsin versus Kelly Newman, and 25 TR 326. The state appears through District Attorney Kevin Schmidt in person. Ms. Newman appears by video conferencing in custody in Burnett County Jail. Her counsel, Nicholas White, appears by video. We're set today in this matter for initial appearances. Mr. White, were you able to go over the criminal complaint with Ms. Newman?
Yes, I was, Your Honor. I can waive further reading of the facts there and the penalty section as well. She understands what she's charged with. We can waive that reading, but I believe we're asking to have a preliminary hearing within timelines. And if Your Honor could address bond today.
Yes, she did file for a bond modification and it has been on the calendar. So we can hear bond. Let me just see what is today. I could do May 14th at 11.
That'll work for me, Judge.
All right, May 14th at 11, preliminary hearing. All right, bond argument, Mr. White.
Thanks, Judge. My client is unable to post the cash bond. I'm not sure what was argued at the last hearing, so I just wanted to make Your Honor aware of that she is asking for a signature bond. The most that she'd be able to post in cash would be about $100 if you would consider either amending the cash bond down to that amount, a much lower amount than it currently is. I've reviewed the facts here and just going off of what's alleged in the probable cause section, it looks like there's some pretty bad facts here with taking the kid and leaving the state. But it also states in the complaint that there's a relationship here. This is not just some random child. This is apparently a grandkid. And that even though it's alleged that Ms. Newman left the state of Wisconsin, it's also stated that she returned on her own. All I have here is the complaint. I don't know some of the other details here about who's allowed to have the kid or some of these relationship factors, but to me it looks like Ms. Newman does have connections in the area. She's got local ties and she's unable to post a current cash bond. I don't believe she has any missed court. I guess I'd leave the state to argue that.
All right, Mr. Schmidt.
I wouldn't object to doing a lower cash bond. I was going to suggest something like $500. I think the court originally set the 10K cash bond because the probable cause statement said kidnapping, which is a very high felony. It's a felony that has use of force in it. The officer who wrote the PC, I think, didn't know the elements of kidnapping. There was no use of force or threats of death or anything like that in this. This is a grandmother knowingly violating a custody order and taking a child out of state. She has one missed court appearance in 2018 in a drug driving offense in Minnesota. Other than that, she's made all her appearances in court. She didn't come back and return the child. The police were investigating, got information about where she'd be returning through Wisconsin. They set up and they caught her and got the child that way. But regardless of the reason I'm asking for cash at all, and this is one, it is a felony. Two, she took the child to another state. And three, she very clearly knew there was a court order for custody here because she knows the child in that relation and she knowingly violated it. So as long as there's the no contact provision at all with the child while this is going on, or the guardian, or where the child resides, I'd be suitable to a lower cash. Thank you.
All right, victims' rights are in compliance.
Yes, Your Honor.
All right, based upon the facts as recitated by the district attorney, the court will amend to a $500 cash bond, same conditions as stated in the previous bond. We will see you on the 14th. We are adjourned. Who's in custody? Who's the gentleman in custody?
Mr. Chafee.
Okay, Mr. Chafee. Have you called the public defender's office?
I have.
And do you qualify?
I qualify.
Do you wish to proceed with your initial appearance here today, or do you wish for me to set it for another date sometime in the near future and hope that your attorney is appointed?
CCAP says he has an attorney. It's Shirlene Perrin.
Oh, well, then it might just be so recent, just like Miss Landgraf was appointed to Miss Chamberlain's, but I don't think that she is aware of it. I'm not certain. It must have been just appointed.
The order appointing counsel was today.
Yep, so I'm gonna guess that they didn't know. And I know that she's not coming back until, Miss Perrin's not coming back till June 4th. So that's a long time. So you have an attorney, Mr. Chafee, so the court needs to move this to another date and time. The earliest I can do would be May 14th at 11:15.
Okay.
All right, so contact your attorney. You should get documentation of your attorney who's been appointed. Contact your attorney and talk to her about this date. If this date doesn't work for her, we'll make it work. I will get a different date, okay?
Okay.
Okay, thank you. Mr. Dynison,
Yes, ma'am.
we're gonna call your case. Have you applied for a public defender?
Yes, I did yesterday.
And do you qualify?
Yes.
And so would you like me to set this to a different date and time to have an attorney, or do you want to proceed with the initial appearance today?
Probably set it at a different date for my attorney.
I can set your date and time for May 14th at 1, May 14th at 1.
Okay.
Okay?
Okay.
All right,
Your
thank
Honor.
you. All right, Ms. Baker, can you hear me?
Yep, I can hear you.
We will go on the record in the matter 25 CM 75, State of Wisconsin versus Rebecca Baker. The state appears through District Attorney Kevin Schmidt in person. Ms. Baker appears by telephone conference with approval of the court. We're set today in this matter for an initial appearance. She's been charged with possession of THC. She has prepaid $250 in bail bond. Mr. Schmidt, is there an offer that can be presented?
The offer I propose is a plea to THC as an ordinance for $250.
Ms. Baker, do you understand what that means?
Could you explain it, please?
It would be he's asking the court to amend it from a crime to an ordinance violation, which is similar to like a ticket, like a traffic ticket.
Okay. Yeah, that'd be good.
Formal motion to amend
So made.
granted. Do you wish to enter a guilty plea or a no contest plea?
No contest.
The court will enter a no contest plea on your behalf here today. I will assess $250. You already have that posted. You're good to go. Thank you.
Thank you. Have a great day.
You too. Ms. Chamberlain, it looks like you have an attorney, Ms. Landgraf, who is a very good attorney, but it looks like she was just recently appointed. And so I'm not certain I'm not certain why she's not here, or that she knew to be here. I can have my assistant call and see if she's available, or email her.
Yes, please. Your Honor.
All right, I will wait and see.
Thank you, Your Honor.
Thank you. Colin Daniels. Colin, have you applied for a public defender?
Yeah.
Do you qualify?
No.
I was gonna say, wouldn't have thought that you did. Are you going to apply for a court-appointed attorney?
Yeah, I was going to.
Okay, you're gonna have to fill out that application before you leave. You have money posted. Now, you are here for an initial appearance. Are you looking at having that adjourned until you can get a court-appointed attorney?
Yeah.
With this case, it's going to require $500 down as a deposit for the attorney, and probably, I'm gonna guess about $75 a month.
Okay.
And so you're gonna need to go fill that out, and if you can pay the deposit today, go ahead and pay it, because we won't appoint an attorney until that's paid. And I can schedule you for, either you can come back May 8th, which is tomorrow at 11:15, or May 12th at 9.
May 12th would probably work better.
All right, May 12th at 9. And I'm going to, if you fill out the application and you get that deposit paid, I'm going to appoint Daniel Chapman. He was just on here, but I didn't know that you needed an attorney. Otherwise, I would have done this already. So go get that stuff taken care of. And once there's confirmation, then he'll be appointed and you can call him and talk to him. Daniel Chapman. Okay?
Alrighty.
All right.
Here's your notice. Here's your notice.
Oh, yep, you can come get your notice.
And so we have them right.
Let's step out of the Wayback Machine for a minute and we'll go to today's action. This is Judge Boyd.
Announce for the record.
Thank you for the defendant.
And are you Rebecca? Just have you seen discovery?
Yes,
Did you review it with your client?
we've gone over it. Yes.
Court will find that the state is in compliance with discovery. Ms. Davis, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented? Ms. Davis, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with driving while intoxicated, third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, she has. She has assisted me.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Davis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $2,000 fine. State recommends community supervision. They're taking in consideration 2024 PF 28045. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No such motions.
All right, off the record. Probation, this is cause number 2025 CR 003154, and it's an application for probation. All right, we're back on the record. Outside the agreement, The state is asking that your punishment be assessed at 8 years in the prison. That your length of probation. See, I'm trying to make sure everybody's awake.
Yeah.
It's shocking everybody's system.
Yeah.
What they're asking for is that your length of probation be 8 years, that there be a TAP evaluation, 200 hours of community service restitution, 2-year license suspension, and they're asking that there be 10 days in the Bexar County Jail as a condition of your probation. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
And state, with regards to the 10 days in the Bexar County Jail, would you object to her serving that on GPS?
No objection.
All right. Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offers exhibit 1 and attachment.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We'd like to proceed, Your Honor.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. Since the date of offense, she has been in a rehab facility. It's now 90 days, and she may be better to explain this facility to you.
All right, what facility are you in?
SOBA, SOBA,
And where is it located?
here in San Antonio. Northeast side, I believe.
All right, I'm gonna have to look that up.
Yeah,
I did
it's
not know about it,
amazing.
so could you tell the judge about
Yes,
some,
I would love to.
everything that they offer and that it's a lockdown facility?
Yeah, okay, so it's typically a 60-day program, and the first 30 days is residential, and you are not allowed to leave. You get 4-hour visits on both Saturday and Sunday. We are in class from 9 a.m. until 4 p.m. They take us to Gold's Gym at 4 p.m. if you would like to go Monday
Well,
through
I
Friday.
need to join that just to
I
get
know,
into
just to get the gym membership. They introduce yoga classes. We have yoga twice per week. We have CBT training, which is cognitive behavioral therapy. I have my own individual therapist and my own individual caseworker. Most of the staff are recovering either alcoholics or drug addicts, so they understand. We have an AA meeting every night from 7 to 8, Monday through Sunday. Yes, we are actually breathalyzed twice per day, once in the morning and once in the evening. And then we are UA'd Monday, Wednesday, Friday, and that's actually sent off to the laboratory as well. And that's typical for your whole stay. Like that's never going to change. After 30 days, you enter a PHP, which is partial hospitalization. I believe they shave off 2 classes, so you have a little bit more free time.
Oh, you know what? Now that you mentioned the hospitalization part of this, I do know about this program because somebody brought someone who actually is over the program to come talk to me about it, but continue.
Okay.
Because I think people should know about this.
Yeah, you enter PHP and like I said, partial hospitalization. They shave off 2 classes, but that's just to have more time to get with your sponsor and go through the steps, that kind of thing. It's very step-based, the whole program. During PHP, you get 2 4-hour passes, one on Saturday and one on Sunday, so you can leave the premises, but they UA you upon re-entry to the facility. And then after the 60 days, you can choose to go into the next 30 days, which is IOP. It's less classes. We only have to attend AA 5 nights per week, but that's when you get a job. The facility actually helps you get to and from work for the whole first month, whether it be Uber or someone taking you. I'm gluten intolerant, and they buy me special food. It's a fantastic facility. So I've learned so much, and just in the short period of time that I've been there.
So how much longer time do you have with inpatient?
So I'm going to be totally transparent. I had entered the facility on February 10th and was released on March 13th. It took about 2 weeks, but I relapsed. I was not doing what I was supposed to be doing, which was attend to AA, talk to my sponsor. I was self-isolating again. And so it took 2 weeks, but the thoughts control the behavior, which control the actions, and or feelings then control the actions. So I did relapse. I then scared the crap out of me because I don't want to be an alcoholic. Well, I'm going to be an alcoholic, but I want to live a nice life. And because I used to have everything and I lost it all. I'm at rock bottom. And so I re-entered the program voluntarily last Monday. It'll be 2 weeks. So I have another 6 weeks before I enter the IOP, which is when I go get a job and everything like that. I plan on staying in sober living afterwards. So that's going to be another controlled environment with UAs and breathalyzing. And I can do that at SOBA. So they actually have, I think it's like 25 acres or something like that. Yeah, it's amazing. It sprawls out. There's a men's house, a women's house, a nursing station.
I have to come and get a tour.
Yeah.
I've had the people at the facility come and talk to me because it really clicked with me when you mentioned the hospitalization part.
Yes, ma'am.
Because the person talked to me and they told me that with alcohol and really with any other drug, of course, you got to detox and all of that.
Yes, ma'am.
And then you got to get your mind straight. But then the hospitalization part is a part of that. So there won't be any
I totally forgot
backslides.
that. Yeah, it's actually considered a dual facility for both rehabilitation from substances and a mental facility. So I am medicated. I have bipolar 2, ADHD, OCD, those kind of things, PTSD, and from childhood trauma. And yes, I'm on a bipolar med. If you can't sleep, they help you with, and non-narcotic, of course, sleep, like melatonin. It's just a fabulous facility. Like all the staff is super caring. The nursing staff, we've got a doctor on call at all times. Dr. Healy, he's a psychiatrist.
Yes. That's who talked to me.
Yeah, Dr. Healy. Yeah, he's awesome. He's awesome. He really listens and doesn't just push pills. Like I can't stand that. Like I don't want to be over medicated. I don't want to be a zombie. I just need the help. So.
Okay, awesome.
Let me just ask a question. So you're locked down for how many more days?
For another 6 weeks. I cannot leave. Well, I can leave the facility, like I said, for the 4-hour passes after 30 days on Saturday and Sunday. But I would not be adverse to just foregoing those passes just to stay in the lockdown, aspect of it. But like I said, after the 60 days, that's when you can actually leave and go get a job. And yeah.
All right, so you're going to have to sign a release for probation. Probation, with regards to this facility where she is, you all can do the UA testing, or you can accept their UA testing, however that's appropriate under your program. So, all right, thank you. So as previously stated, the court is going to find you guilty. The court will sentence you to 8 years in prison, suspended and probated for 6 years. There's to be regular reporting by Zoom or in person. You to continue with treatment at SOBA, SOBA?
Yes, ma'am.
All right. There is to be a 2-year license suspension. All right, with regards to the GPS, if she were on full lock time at that facility and they were not allowing her to leave, I wouldn't even do GPS because she would be there.
And that was where I was trying to go to, because we had talked about that. And if the court instructs her that she's still within that lockdown for 2 more weeks, and then she would be where she got some freedom, but the court could order that she could not leave the facility for those 4 hours.
Those other 30 days.
All right, so
It's up to y'all.
then,
I mean, I
well,
would-
here's the thing, GPS is expensive.
Yes.
Yes, ma'am. And I am indigent.
Yeah.
Like I said, I've lost everything.
All right, State, do you have any objection to the court ordering that, since she's at SOBA, that for the 10 days, she is to be on their lockdown and not leave campus?
As long as there's verification that she does remain on campus for the entire 10 days, then no, the state is not.
All right. So in lieu of the 10 days in the Bexar County Jail, I'm going to order that you're to remain at SOBA on their lockdown
Yes, ma'am.
and not leave the campus.
Yes, ma'am.
And she was brought here by the facility.
Yes, they
Oh,
take you
yeah.
to appointments.
Oh, where are they?
They're not in court.
Okay.
Yeah, I just call them and
Yeah.
they come pick
All
me
right.
up. Yes, ma'am. Like I said, it's a fantastic facility. I just can't get over the level of care and understanding, just because, like I said, most of the staff, even my therapist has a master's degree in social work and he is a recovering alcoholic. So he does this amazing therapy called EBDT.
Mhm.
It's fairly new. It's about 3 years old and it's like hypnosis based.
Mhm.
And you target like a traumatic memory and he walks you through and it's got this wand. It's really weird, but it is like magic. So yeah, it's great therapy.
Okay. All right, and then there will be, and as I previously stated, in lieu of the 10 days in the Bexar County Jail, there's to be complete lockdown at the SOBA facility for 10 days. DWI education course, VIP live, DWI intervention. And if they have those programs at that facility, then those will count towards that. But you will need to give a release to probation so that they can make sure that those programs are equivalent to the programs that I'm requesting.
Yes, ma'am.
All right, there's 200 hours of community service restitution. Do you have any children?
I do. They don't live with me. My 14-year-old lives in Kyle with his father, and then my 23-year-old is on his own. He's very successful.
All right. I'm going to order parenting classes. Once she completes that, the community service hours will be deemed satisfied. Do you have any vehicles?
No, ma'am. Well, I have a vehicle right now, and that's something that I would like to discuss as well. It's about to go back to the bank. Like I said, I'm indigent. I have no way to pay for it. Plus, I haven't been driving it. It's been sitting in my boyfriend's driveway, but with the breathalyzer on it. Like I said, it's going to have to either get sold back to CarMax if they accept it or go back to the bank. And I was hoping to get a release of breathalyzer off the vehicle because I cannot, excuse me, cannot sell it or turn it back to the bank with the Smart Start device on it. I would not be adverse to getting an in-home device. That's, I know that's typical.
All right, so what I'll do is, it's going to be ignition interlock for half the term, or you can provide an affidavit of non-driving, and the court will order a portable alcohol monitoring device.
And will that allow me to, because I believe Smart Start needs proof of a judge release?
They're going to give everything to you.
Okay, yes, ma'am. Thank you.
There'll be field visits one time per month for 6 months. Proof of employment within 45 days of release from SOBA. There's to be no employment as a home health care provider or with minors. And I'm going to order 120 sober meetings in 120 days. I know you're already doing that there, and you'll need to make sure that they receive that.
Yes, ma'am.
Take in consideration 2024 PF 28045. Probation, is there anything else?
No, Judge, I think that'll be it.
Is there anything else you need from the court in order to be successful?
No, ma'am. You've been extremely helpful. Thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about that, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. I'm glad that you are taking this seriously, because alcohol and driving just does not mix. You could easily kill someone. You
Yes,
understand?
ma'am. And I thank God every day that I did not harm someone else and I didn't kill myself. So just because I don't my boys would be devastated and my family in general, so.
Well, here's the thing, in this court, your attorney will tell you, communication is key to successfully complete probation in here. If there's an issue, let your probation officer know. If you feel they're not addressing it, you can always come back to court, okay?
Yes, ma'am.
All right, good luck to you.
Thank you.
Just remain in court probation. We'll go over conditions.
Yes, ma'am. Thank you.
You're welcome.
Alrighty, I've got a pretty good suspicion just looking at the current stats on the stream that we've got a bunch of new viewers this morning, probably people that are hunting around for a new home since there's no Judge Fleischer. So if you are out there and you are new, welcome. Feel free to say good morning in the chat. We're a very friendly community here. We're very focused on the law and learning and just enjoying a couple of hours together every morning. So feel free to say good morning if you're new to us here. Let's stick with Judge Boyd for a couple more minutes, see who else she might bring up.
You all ready to proceed?
I'm ready, Judge.
All right, court is calling 2022 CR 10261 State versus Nathan Martinez. Could I have parties announced for the record for the state? Defense?
Larry Meadows for the defendant.
And are you Nathan Martinez?
Yes, ma'am.
Are you this, did you review the document entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same Nathan Martinez who was placed on community supervision in 2022 CR 10261 for the offense of felon in possession of a firearm on May 23rd, 2023 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
The court summary does not include a copy of the motions and
Here.
does not identify its name.
Here.
Yeah, I've got it.
In Bexar County, Texas, the defendant Nathan Martinez did then and there fail to report to the supervision officer as directed for the months of August, September, October, November, December of 2024, January, February, March of 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State waives the remaining violation allegation.
Any objection?
No objection.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you up to 8 years in prison and up to a $250 fine? Did you understand that?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am, I do.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes.
Yes.
And what is that proposed agreement?
Deny the motion. Requires state ISF amends for moral recognition therapy. All of the conditions remain in full force and effect.
That's the agreement.
All right, so here's the court's question. From reviewing the, well, let me do this. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do, ma'am.
All right, you can lower your hand. State your name for the record.
My name is Nathan Ryan Martinez.
All right, why are you not reporting?
Well, I had a drug problem and I started using drugs again. Whenever I got out, I was gone for about 2 years, then I had to go to ISF and I went for the 6 months. So I was gone for quite a while and I lost all my social security and my ID. So whenever I had got out, I was in the process of getting that and I ended up getting my social. And I was going to get my ID, but it was a 3-month waiting period. And with that time, I started going into my old ways and stuff. So as soon as I started using again, I stopped reporting. And I mean, I was just in limbo to then waiting to get arrested.
Okay, because I noticed in the motion to revoke, I'm not considering it, but I noticed that you had a lot of UA issues, alcohol and methamphetamine and amphetamine. So that's a problem. All right, I'm going to give you a choice, right? You're at a crossroads in your life. and it's completely up to you what you choose. I can revoke you. I will sentence you to 3 years in the prison. And sentence you to 3 years in the prison. A therapeutic community. Give you credit for any time served. And there's to be no contact with Daniel Pizzuto, Pizzuto Jr., Deborah, Debra, Pizzuto, Desiree, Dezeray, Sanchez. And there's to be no contact with minors. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review this document with your attorney? Did you understand it and did you sign it?
Yes.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
We can go off the record. If you don't change your life, only two possible outcomes are for you. One, you're going to end up in prison or jail for the rest of your life. Or two, somebody's going to have to identify your body in some field or on a sidewalk or somewhere. You understand?
I do.
You need to change your life. All right, good luck to you.
Thank you, Judge.
You're welcome. And if you all give the court summary back to probation, please.
Bailey Ellie thanks you for the $4. Very kind of you. With any luck, she actually makes an appearance later. She's sleeping right now. She's been sleeping a lot in the mornings, but she's been up a lot at night. I don't know why. She's just wanting to make sure that I don't get to sleep, I guess. So who says we can't have Harris County? Let's go to Court 13. This is Judge Raul Rodriguez. He's still streaming, though I will say I've been watching him for about the last half hour, and he used to show his face on camera, and he's not. So I don't know if this is something he's trying to get around things. I don't know. But let's watch him for a few minutes.
Conference 814, if you can give her a copy, and can we give her a work excuse? Okay, just step right over here and we'll give you a work excuse. Thank you. Mr. Mayor, good morning. Oh, is that what you have, Sam? Oh,
Yes,
good to
Judge,
see you.
thank you.
Your excuse. Thank
You
you.
too. Thank you.
Thank you.
Never mind. He's back on camera. I don't know what I'm talking about. But he has muted himself. So let's do this. Let's hop in the Wayback Machine. And this is Judge West from the other day, but we haven't seen any of it, so let's go there.
I don't have an objection to his withdrawal, Your Honor. I understand the conflict, and as far as the offer and everything, I know Mr. Smith has been over it several times, and I don't see why it would change, Your Honor.
So, Mr. Jenkins, because of, you probably already talked to him about that, I'm not sure, but he's not going to be able to represent you just because of where this happened or allegedly happened. And so what I'm going to do is release Mr. Reynolds today. I'm going to appoint an attorney today. We're going to contact them personally, let them know that you're ready to go forward with trial, that someone else has looked at it. Mr. Reynolds, if you will make sure and get everything you've received once we get that new attorney to them as far as discovery goes, if there's any media, especially, obviously the discovery portal stuff they can get, but if you've received any media, then if you'll get that to that attorney, and then they'll be out there very soon, and we'll have one more court date with that attorney, and then we'll get it moved to the trial docket. Okay, you can go back with the bailiff. Yes, sir. Mr. Kimler, you've got James Wheeler, 23 DCCR 1800. That's Anna.
I'm sorry.
That's okay. Thank you. Good morning, sir. Are you James Wheeler?
Yes, ma'am.
And let me get myself up to speed here. Mr. Wheeler, amphetamines, not adhering to a curfew, amphetamines, not adhering to a curfew, being behind in his fees a little bit, and then failing to report for intake in Hardin County. So there was, it looks like, a recommendation of safety after a substance abuse assessment was done on April 16th of 2024 that we're now with the motion to revoke. Mr. Kimler has filed a motion asking that I set a bond. Mr. Wheeler is on a deferred probation, typically entitled to a bond unless there's certain findings. Actually, this is a straight probation. It's a 2/5. Okay, I've received some information that Mr. Kimler sent over. Do you have an opportunity to review that? Mr. Kimler, you may proceed. Did you want to call your client?
Well, I think I'll let him decide that, Your Honor. Just in speaking on his behalf, if he wants to address the court, I'll let him do that. But this is a non-violent offense. My first observation, of course, many times when I move before the court, I know that the state argues the safety of the community is paramount in consideration of the bond. I'm not trying to downplay the seriousness of fraudulent use of identifying information offense, but I would just observe to start with that it's not a crime of violence. Mr. Wheeler's struggled on probation. We want to get him back on track, and as part of that, it would be admission to bond where he could report, continue to work, hopefully not have a positive drug screen, so when we come back in front of the court for a disposition of the case, the court's going to revoke him or keep him on probation. He'll be in the best possible position to argue that he should be remaining on probation.
Speak up, please.
So that he would be in the best possible position to ask the court to continue him on probation if he would have the opportunity to be in bond, show that he can demonstrate compliance.
Okay, Mr. Nichols.
If he's, whatever bond the court deems appropriate is fine by me, Judge. He just needs to monitor. He needs a drug patch. He needs to be reporting. And seems to have a problem doing those things when he was on probation before. I'll note for the court, on a separate probation, he was sent to safety in 2020.
I saw that.
And obviously it has not worked. So I agree it's not technically a violent offense, but his drug use is concerning, Your Honor.
You want to address the court?
If I may.
Hold on. Raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead.
I have had a history of drug use. When August 4th, my firstborn child was born, and when I heard her cry, I was done. I never touched it again. I put myself in the Franklin house as lay manner. I went there for 30 days doing aftercare. CPS was with us up to taking 9 drug tests, negative, and a hair follicle. I'm just ready to provide for my family. And that's why I turned myself in, so I can go back and get this out the way and fixed to where I can go to work, because I couldn't get a job. because of the warrant. And I'm really excited to be a father. So it's really, I'm trying to put this on the right track so I can get moving.
So one of the things I did get one of those letters is from the caseworker that had some positive things to say. So I'll deal with the bond. I'll set one, but what's the plan? I mean, do we not want to go ahead and go through the motion while we're here, and that way we can then set it for, instead of coming back? So will he waive the formal reading of the motion? So we're gonna go through this motion, get pleas of true or not true to those allegations, reset it for sentencing, and then we'll talk about the bond and conditions of that in just a minute, okay? So I have in cause number 23, DCCR 1800, motion to revoke your community supervision. Shows that you were placed on probation March 19th of 2024 for fraudulent use or possession of identifying information. That was a 2-year term in the state jail prison that was probated for 5 years. Is that right?
Yes, ma'am.
It alleges you violated your probation. Count 1 alleges that you committed the offense of public intoxication March 26th of 2024. And is that true or not true?
Yes.
Count 2 alleges that you provided a urine sample April 16th of 2024 and May 7th of 2024 that tested positive for methamphetamines. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample April 16th and May 7th that tested positive for amphetamines. Is that true or not true? I'm sorry.
True.
Count 4 alleges that you were at a location other than your residence at approximately 11:15 p.m. March 26th of 2024. And is that true or not true?
Yes. True. True.
Count 5 alleges that you are, as of May 7th, 2024, you were $240 behind in your fees. Is that true or not true?
True.
And then count 6 alleges that you failed to report to the Hardin County Probation Department for your intake on April 9th of 2024. And is that true or not true?
It is true, but hard
True,
to
true with an explanation.
Yeah, we'll get an explanation later. All right. So did you enter your pleas of true to counts 1 through 6 freely and voluntarily? And did you plead true to those counts because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I'm not going to do that. I'm going to reset your case for a sentencing hearing and ask the probation department to do an updated report. And so I'll get a little more information about what's going on. Now, with regard to a bond in your case, I'm going to set a bond at $5,000, but you're going to have a condition of that bond if you make it, that you have to wear a drug patch at all times. You've got to have a drug patch put on within 24 hours of your release from custody. If it tests positive, then you're back in jail and all bets are off.
Thank you so much.
If there's more, if you have a drug patch that's not testable, I'm going to assume it's positive. So you need to make sure, wear it properly, do whatever you need to keep it on, and go every 2 weeks like you're supposed to get it tested. I think, I don't know exactly what I'll do. I mean, obviously it sounds like some treatment would be required. Wouldn't hurt to go ahead and get started on some outpatient maybe. But we can wait, or you can go ahead, probation's here, and whatever you think is appropriate at this point while we're waiting on sentencing, give those orders and I'll sign off on them.
Yes, ma'am. I was going to give him a new assessment done to see exactly what it is that he needs and get him started.
Perfect. Okay, because it sounds like since the last assessment, there's at least been some treatment, so maybe that'll, recommendation will change. Okay? All right, you can go back with the bailiff.
Yes, sir.
All right, let's go back into live mode and we'll go back to Judge Boyd.
To the court.
Yes, ma'am. I've spoken with the complainant. This is the outcome that she wants, and that she feels comfortable.
And how is the complainant?
20. Well, I'm sorry. She's born in. She's 26 now, Your Honor.
All right, and so the complainant is now 26 years old, and this is what she's requesting?
Yes, Your Honor.
Okay. Court is calling 2021 CR 2011 State versus Javier Herrera. Can I have parties announced for the record? State.
Ashley Jones for the state. Lindsay Shaw, I'm sorry, Lindsay Shaw for Mr. Herrera.
And are you Mr. Herrera? Did you review this document entitled deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am, I did.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are proceeding only on count 2, which is indecency of child.
Did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor, I did.
Did you understand the state is proceeding on count 2, indecency with a child by contact? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Herrera, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, there's a $1,500 fine. There's to be no contact with the complainant in Chapter 62 registration, and the state is recommending deferred adjudication. Did you understand that to be the plea?
Yes, Your Honor. I did.
Defense is at the plea.
Yes, ma'am.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, ma'am.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 5 years, 200 hours community service restitution, and you're to be supervised by the sex offender unit. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State offer states exhibit 1 in all attachments. No objection.
All right, did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. All right, so why am I following this agreement? Or I should say, why should I follow this agreement?
Your Honor, we have discussed this agreement at length with the complainant, including just proceeding to trial and having a jury decide whether the defendant is guilty or not guilty. She understands everything that comes along with the trial and everything that would come along with this plea agreement. And she has chosen, or at least let the state know, that she would, her preference would be to go forward with the plea.
All right, and now the former child is now an adult?
She is, Your Honor, and I did misspeak earlier. I aged her by a year. She's only 25, but she does not have any contact with the defendant. My understanding was that the defendant was married to the complainant's mother had gotten divorced and has been divorced from their mother for quite some time now.
All right, do you have any other children?
Yes, Your Honor, I do.
And what are their ages?
10 and 5, Your Honor.
All right, I'm not going to allow you to have contact with minors. I'm not going to allow you to reside in any household with minors. You can't be trusted around children.
Yes, Your Honor.
So I'm going to give you a choice. Here are your choices. The state is asking that your community supervision be for 5 years. That's a recommendation for them. I'm going to make it 10.
Yes.
Or either if you all would want to negotiate a prison term, you can. Otherwise, it's going to be 10 years deferred adjudication.
Yes, Your Honor.
So do you want 10 years deferred adjudication?
Yes, Your Honor.
All right, there's a $1,500 fine. 10 years deferred adjudication. There's to be no contact with minors. No contact with the complainant. Chapter 62 registration. Regular reporting, and that's going to be in person. Regular random UAs. Proof of employment within 35 days of release. There's to be no employment as a home health care provider or with minors. There's to be no residing in a household with minors. He's to be supervised by the sex offender unit. They're asking for community service hours. There's no community service hours I can give you legally because there's no place that will accept community service from you. There's going to be 180 days in the Bexar County Jail as a condition of probation. Probation, is there anything else? And we can do a TAP evaluation while in custody.
No other, thanks, Judge.
All right, there'll be a TAP evaluation in custody. Follow recommendations. Is there anything else you need from the court in order to be successful?
Oh, yeah.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So what I can tell you is the complainant saved you from going to prison. Because in this specific case, if the complainant still would have been a child, I would not have followed this agreement. But because she's an adult, I realized that maybe her mother or somebody is not pulling strings. You understand?
Yes, Your Honor.
All right, is there anything else?
Yes, Your Honor, we do have victim impact statement. We are having a little bit of trouble getting the link to the complainant. I would just ask maybe for about 5 minutes so that.
All right, then, what we can do is, if she is she able by phone?
Yes, Your Honor.
All right, so then what we can do is if he'll go into the box and then you all can play the phone for him where she does her victim impact.
One thing we missed was the field visits.
All right, thank you. Field visits 1 time per month until further notice.
Judge, if I may, my client, when he was arrested, he's been living in Cheyenne, Wyoming for the last 6 years. We would ask once he's released from custody if we could have this transferred to Cheyenne, Wyoming.
Do we know what county that is?
I can look it up really quick, Judge.
All right. And I'll look it up as well. And there's to be a transfer to Cheyenne, Wyoming. You're not transferred unless they accept you. Do you understand?
Yes, Your Honor. I got arrested when I was on my way to work, and I left my belongings over there to my employer. So I have no ID, no social security.
It's Laramie County.
Okay, thank you, Judge.
All right, thank you. All right, thank you.
Thank you, Judge.
And then Lindsay, on Abel Hernandez, I'll give you a reset.
Okay, thank you, Judge.
I'll give you a 30-day reset. What day for you is good? I can do it we can put it on June 26th. You're okay with that?
Yes, ma'am, that works.
Okay.
Thank you, Judge.
You're welcome. All right, Mr. Hernandez, we're gonna bring you back on June 26th, okay? And this is gonna be your new attorney. All right, thank you.
There we go. All right. You were stubborn this morning. Everybody say hi to Ellie. It took some real yeah, hi. Oh, thank you. That's very nice of you. Good kisses. And now you're done. She's weird this morning. So let's change it up a little bit. We're going to go to the 44th district. This is normally Judge Meineke, but we'll take a look at the magistrate, one of the magistrates for the 44th. This is Magistrate Jill Banky, and we'll spend some time there.
Yeah, can help us. He's right there. We'll call him in if you want. He's the one who assigns all the.
I'll try calling again. Oh, okay.
He can pull somebody in for us.
Well, I don't have the defendant here. That's why I'm thinking they're both in another courtroom.
I just sent them. Do you want me to just physically run upstairs and check? How about I just do that? If you wait for me, I'll run upstairs.
No, she probably doesn't. If the judge isn't here, they're probably not running Zoom.
They're not even.
Yeah, for those of you who might be new with us this morning, Ellie is the quasi-co-host here at the Courtroom Files. She's been more absent than not lately, though. And now she just laid down at my feet. One of her favorite things to do is guard my feet. Oh, nope, now we're up here. And Io's in the studio. Do you want to... She never comes in here. Do you want to say good morning, Io? Probably not. You don't like to be picked up. But if she jumps up, you'll be able to see her. All right, let's go back to court because you all don't want to hear me talk about my cats.
Hey, Courtney, thanks for thanks for the phone call. I was just literally switching over. That's why I couldn't. I had just gotten off
Were
the
you
phone
in the
with-
wrong?
Yeah, I was in Judge Kowalski's Zoom ID room.
That's what we figured. No big deal. Okay, is your client here, sir?
Oh, yeah, I guess he's got the wrong Zoom ID too.
Is he in the jail? No, that is a
No,
different
he's not.
client.
Courtney, do you know, are these officers still around? Still employed? Oops. Should we get a breakout room? I'm sorry, I thought we were alone.
Nope, you're in the main session. I can put you in a breakout room.
Please, thank you. Hey, John.
JT.
Okay, Mr. Taylor, do you have your client coming on?
Looks like you went on the breakout.
Yep.
Judge, I'm going to join if I may. I've got a breakout room as well.
I gave you, yeah, I did put you, wait. I had you in 2 and now you both came out. Do you need to go? Did you ever go in?
I never did. I just,
Okay, so I had you both in room 2, but I'm gonna move you to room 3. I'm gonna move you to room 4.
okay.
It's
Now I
hard.
got it.
Not everyone knows how to join.
Okay,
Room
thank you.
4, room 4, room 4. Thank you. Okay, I see that your client's here. Do you want your client to join you in the breakout room, Mr. Taylor?
No, I've already talked to him previously, Your Honor.
Oh, okay. So are you done in the breakout room? You just coincidentally came back in right when he joined, or do you need more time?
Yes. Yes, Your Honor.
You need more time or we can go?
No, we can go. I
Okay.
think the only thing we need to cover is
No,
the
that's okay.
21
Let me call the case, please. I always want to give you time so you can get, things taken care of and no rush. The case, Madam Prosecutor, are you ready to go?
Yes.
Okay, calling the case number 15-86187. This is the state of Michigan versus Anthony Trevino. Your appearances, please.
Good morning, Your Honor. Courtney Rosenau on behalf of.
Good morning.
Good morning, Your Honor. John Taylor on behalf of Anthony Trevino. We are consenting to Zoom this morning. Mr. Trevino, could you please state your name for the record?
My name's Anthony Trevino.
Good morning, sir. All right, today's the date and time set for the first PCC. I'm standing in for the judges, for your judge who's at a conference this morning. And counsel, how do you want to proceed today?
Honor, we do wish to have an exam in this matter to see if the officers actually are still around. This is an older case. Your Honor, it's my understanding the prosecutor assigned is on vacation next week. So I haven't talked to my client, but we have no problem with it waiving the 21 days for them to maybe work on subpoenaing those people.
Okay. Will you forward your client on that, please? Sir, will you raise your right hand? Do you swear or affirm that the testimony you're going to give to the court is true?
Yes.
Okay, go ahead, counsel.
Thank you, Your Honor. Anthony, we talked about the fact that we may ask for an exam in this matter, correct?
Yes.
And we're entitled to that exam within 21 days. Due to the age of this case, I don't see any issue with the waiving the 21 days, and the court wants to make sure you're good with that also.
Yeah, I'm fine with that.
Okay. Nobody's threatened you.
Is the standard in the court rule? Are you good with it?
Sure.
Do you voluntarily give up your right to have a preliminary exam within 21 days of your arraignment, sir? Such that it will still take place, but it will take place after 21 days. You're not giving up your right to an arraignment. Do you understand that?
Oh, yes, yes.
Okay, and you want to waive those 21 days?
We'll be on with you again here in a second.
1 second, please. I got to mute the jail. I'm sorry. And you want to waive those 21 days?
Yes.
Okay. Do you understand what that means? Like under the court rule, there is a requirement that the preliminary exam take place within 21 days of your arraignment, but a defendant may waive that 21-day condition and have the preliminary exam take place beyond 21 days. And your attorney, Mr. Taylor, is saying that he thinks it's in your best interest to do that because because the prosecutor assigned on the case is on vacation, but you're still going to have the preliminary exam. Do you understand that? What's occurring? And you're in agreement with
that?
Yes,
I understand that.
Okay.
Yes.
Okay, so we will, do you want to set this for a second PCC or just set it for a preliminary exam?
We just set it for an exam, Your Honor. I think June the 6th would give prosecution enough time.
Yes. I don't do the scheduling, but I will put in here that June 6th is an available date for you, but I don't have the authority to say, yes, that will be the day.
So in the past, Magistrate Banky, when you've covered dockets, we've heard directly from the court within a couple business days about the scheduling for the exam.
Right.
So usually the date that you give is fine. I don't think Judge Kolakowski is backed up.
Yeah, I'm going to put it in here. I just don't know the judge's schedule. So I'm not privy to that and I don't do the docket. So I put the request in and then the clerks handle it. And if we can accommodate it, we will. But I have no idea. Maybe Judge K is at a conference that day. So I can't speak, but I'm going to recommend it. Okay.
Sounds good for the
Thank
people.
you, Your Honor.
Okay,
I have a
is
lot of
there- oh.
conflicts myself.
Okay, and Madam Prosecutor, did you have any questions on the waiver for the defendant?
No.
Okay, so the court finds that the waiver of the 21-day requirement is voluntarily, knowingly made, and therefore the 21 days will be waived. We'll set this matter for a preliminary exam. June 6th is the requested date for the exam. And I'll note that in the file. Is there anything further the court can do to assist the parties at this PCC? Anything further?
Nothing from the people.
Okay, thank you, sir.
No, Your Honor, thank you.
Okay, thank you so much. May both leave the Zoom. Take care and be well.
Thank you.
Mr. Trevino, you can leave
Thank
the
you.
Zoom. Okay, thank you.
Okay, thank you. Thanks.
So yes, that was Io. I think honestly that's the first time she's made an appearance on the show, because she normally doesn't come in the studio. Io is a tortie. She's a monster-sized cat, but she's actually only 3 months older than Ellie. So she's still kind of a kitten, just like Ellie, but she's huge. She's a powerhouse too. She's hard to handle because she's so strong. No, you can't go up there. But she's still learning studio rules. She doesn't know where she's allowed to go and not to go, so I'm going to be doing more yelling at cats, I think, for the next 30 minutes while we're still live. Anyways, let's continue riding with this magistrate for a little bit.
Okay, Mr. Angott.
Yes, Your Honor, we are ready.
Okay, thank you. Which gentleman?
I'm sorry. This is
Oh, I
Mr.
only have
Taylor.
one. I only have one with two.
Yeah. Judge, just so you know, I've chatted the
Yes, yes.
to both you and
I really appreciate that. I really appreciate that. Mr. Angott, can I ask you a question, not on this file, but on the previous, you were just there on that PCC, and Mr. Lumberg arraigned that individual, but then I think he had Mr. Taylor, and I am trying to learn the process.
it's actually very simple. The only attorneys in this court, the only attorneys who stay on a case after arraignment are the scheduled arraignment attorneys, the 4 days that you have. Well, you only have it 1 day a week, but the Monday, Tuesday, Wednesday, Tuesday, Wednesday, Thursday, Friday, they'd be, Joe Schreeman or Chupak or that crew.
And, no, Gagniak. Agnew.
Yep.
Okay, so if they're not just the in custodies, but they're the one, Steinberg, they do the scheduled ones.
They're always scheduled. They stay on those cases. The attorneys who do the arraignments next door or Berkeley, my crew, we don't stay on those cases. And then if it's a felony, the appointment comes out of the office in Pontiac.
Okay, so I think that was, so that was Mr. Taylor, but I don't see an appearance filed, like a piece of paper in the file that says appearance, but somehow it was on our ROA, right? So how does that happen? Like how, when I pick up the file, how am I supposed to know who it is?
That I don't know, because if it's the IDSO office, and I thought that they would provide to the court a written
Right.
written
Yeah. All right. I'm just learning. I'm just trying to learn because I don't always get the whole picture when I'm only here one day.
Right.
Okay, Mr. Taylor, good morning. We're going to call your cases for the arraignment. Okay, sir?
Yes, ma'am.
Okay, you have two cases. I'm going to call the older case first, 2300286, which is the City of Royal Oak versus James, is it Darius?
Yes, ma'am.
Darius Taylor. And then we have 2500803, which is the City of Royal Oak versus James Taylor. So, Mr. Angott, why don't we go oldest to newest?
Sure.
Okay. So I'll take your appearance as noted for both, and then we'll go oldest to newest. So your appearances, please.
Thank you, Your Honor. John Angott appearing on behalf of Mr. James Taylor as to the 2023 case. Mr. Taylor, would you please state your name for the record?
James Darius Taylor.
Thank you. Judge, we're both here via Zoom. We both consent to the use of Zoom for this hearing. I did speak to Mr. Taylor as to both charges or both cases. We talked about the charge, the nature of the charge, the possible penalty, and more importantly, we talked about Operation Drive, which
Very good.
he was unaware of. But it's a program that I think he's perfectly suited for. We want to get a license in his pocket, and as the court knows, this is something that the 40.
Oh, please, let us help you, sir. Let us help you, okay?
Thank
We
you,
have
Your
a
Honor.
great program here. Please.
So I would waive formal reading. Well, as to the bench warrant, I respectfully request the court recall that bench warrant. And then if he's not been arraigned on it as to the charge, I would waive formal reading and stand him mute.
Okay, so with respect to the 23 case, this gentleman has never been arraigned. So we will waive the formal reading. Defendant stands mute. Defendant address is on Lamont. Sir, I think I grew up near you, where you live. Yeah, I know. I recognize the zip. That was the zip code where I grew up on the east side, huh?
Oh, okay.
Yeah. So I know the area well. Okay, so defendant's address. And did we have a phone number for this gentleman? Let's
Yes,
see.
John.
I didn't get that far. Okay, I have it. Just give me 1 second, please. Okay, so on this 23 case, we're going to waive the formal reading based upon your representations. Defendant stands mute. I've confirmed his address and his phone. A not guilty plea to enter. We'll set aside and recall the warrant. And assigned counsel request, correct, is requested.
Yes.
That's granted.
Thank you.
Counsel shall be assigned for this gentleman. He is an Operation Drive candidate. Okay, sir, here's my big spiel. Nobody likes coming to court. I can be positive you probably don't like being in custody, okay? But we have a program here. Mr. Angot's very involved in it. Our judges, Judge Meineke spearheads it, okay? This is his baby and his passion. And we work with people and defendants such as yourselves. Might take a long time, no promises and no guarantees, but this court does what it can to help get you licensed. We have a lot of resources. We have a lot of know-how, okay? So if you could please work with us to help you have a better life, I would appreciate it, okay? Like I can only lead a horse to water, okay? So please do what you can to listen to the attorneys and make all the court appearances. Because if we got you a license, you and I would never have to meet. Okay. And it would, and in this city, you have a better life if you have a license.
Okay, that's fine.
Okay. You do. I mean, it's sad we don't have,
I'm just ready to go home. We got to jail.
Okay. So you work, Mr. Angot will probably be in the program with you. We have other amazing attorneys. We have great court staff. We have so much knowledge here on how to work things in your benefits. So Mr. Angot, how many people have we gotten licensed? Like 2,000 or something?
It's getting up to about that number, Judge.
Yeah. So, okay. Operation Drive, we're going to set for a pretrial. The bond on this one is $2,500 personal bond, but you have to give me your word. You're going to listen and you're going to appear.
You got my word.
You're going to appear. No playing. Okay.
You got my word.
Your bond conditions on the 23 case are that you have to personally appear by Zoom or in person. Now, we do, like right now, you and I are by Zoom. If you do not have the ability to Zoom, like you don't have a device or you can't do it from work or you don't know how to do it, you can come to our court and our court officers will put you in a room and set you up. Okay, so no excuses. We do everything we can to get you in a good place. Okay, you have to abide by any judgment and in this case, surrender to serve any sentence imposed. You do not commit any crime while released. Do not drive without a license or permit.
Okay. So I won't drive.
All right. If you drive, you violate this bond. Okay.
All right. I won't drive.
All right. You have to immediately notify the court in writing of any change of address. If you move, sir, from Lamont, and we don't know how to call you or give you notice, and you get a default in the bench warrant, it's not going to help you get your license. Okay.
Okay.
So you have to help us stay in touch with you. The bond I set on this first case is 2,500 personal bond. Okay, Mr. Taylor?
Okay.
James Taylor, you know, there's a famous singer named
Yep,
James
I
Taylor,
know.
and I'm talking to you and all the songs are going through my head. Okay, so that concludes the arraignment on the 23 case. Now I'm calling the 25 case, Mr. Angot, for purposes of efficiency. Everything you've said on the 23 case, does it apply in this case?
It does, Your Honor. Thank you.
Okay, Operation Drive. Do you
Yes.
have any objection if I just say everything we've done in the 23 case applies to 25? I'm going to set the same bond, 2,500 personal.
I'm a big fan of judicial economy, Judge.
Okay, so Mr. Taylor, everything I said in the 23 case applies to the 25 case. You're going to be in Operation Drive. You just have 2 cases with us. You're going to have an assigned counsel. We waive the formal reading. You don't have a bench warrant in that case, so we're not going to set aside and recall the bench warrant. But the bond is the same, and you're going to get the paperwork, and you don't need to post any money today for your release. Okay?
Okay.
Okay, please stay in contact with the attorneys and do what you can, okay? Help
Sure
us,
will.
help us.
I sure will.
Don't disappoint me in the 48234.
James, I'm gonna report back. Judge, I'll let you know how he's doing.
Okay, so I have OCJ now, Mr. Angot. We don't have anyone else. Ready?
Judge,
Okay.
may I just say hello to Miss Smithson?
Yeah, go ahead,
Never
go
met
ahead.
her. You're the second Miss Smithson, and for a long time I thought, you know, the MIDC former regional manager, but now I get to see you. So
I need to
hi.
write this out. It's I need to. I need
Nice to see you.
to.
Thank you, Judge.
Okay, thank you. Okay, do you need to go into a breakout room, Miss Smithson?
So what Magistrate Banky was saying about their Operation Drive program is true. If you watch enough court out of Michigan, other judges across the state reference that program because it's so good. And it's Judge Meineke, who we often watch, who actually heads that up. I've watched a couple of his streams with the Operation Drive people, and it's interesting. They really put in a lot of work to get these people on the road properly, licensed, insured, all of that, and it's a good program. We got about 10-15 minutes left. Looking at what we have for live options, this is probably still the best. So unless you guys tell me you don't like Magistrate Banky, we'll just continue with this for a little while.
1 second. Let's have him state his name, and then I'd like to mute him because I'm getting interference. Go ahead, sir.
My name is Andre Delorbusier.
Okay, sir, I'm going to mute you, not to be rude, but it's just not working with the technology. And if I need to hear from you, I'll unmute you. 1 moment, please. Go ahead, ma'am.
Good morning, Your Honor. Nicole Smithson, P71404, appearing on behalf and with Mr. Bussier for arraignment purposes only. I've had the opportunity to speak with him, advise him of really it's an old case from 2017 where he just owes fines and costs. It looks like there was a bench warrant for perhaps failure to appear for a show cause hearing.
Correct.
It looks like the fines and costs are $237, if I'm not mistaken. We'd ask to recall the bench warrant. Just reset the matter in regard to bond. He's 49 years old. He is a maintenance.
Well, I'm going to set a personal bond in this case because it's only a money case. But, sir, is a good address for you Fordham and Kiko? Or okay, that's still a good address. And I don't know why he is in custody, but how many days out should I set the show cause? Oh, 1 second. I don't know if I can get him to unmute. I don't think he can operate the, let's see. Can you operate the device? I don't think you can. I know I made a mistake. You know what? This is what's going to happen. We're going to make him leave and we'll invite him back in. Okay, so we have to kick you out and call you back. Wait, did it work?
I don't know, did it work?
Yes. Okay, now we don't have to do that. Whatever good juju it is, let's keep it going. Okay, so we'll recall and set aside the bench warrant. Okay, and Madam Clerk, did you confirm the amount owing?
The amount warning is 237.
Okay.
It does look like you're gonna switch the bond, so I'll just leave that alone.
Right. He did post several bonds before which were forfeited. Okay, so go ahead. If we set this for a show cause, how many days out? I don't know your current status.
I don't know my status either right now, but I figured maybe 10 days.
Oh, okay.
I'm not really sure because I don't
Okay, that's
know.
okay. I'm just gonna put at least 10 days out.
He's being arraigned on a felony matter out of the 48th.
Okay.
I don't know who's arraigning in the 40.
I don't either.
So I can't speak to what kind of bond he's about to get. I will say this is his only.
Right, I'm setting a personal bond because it's just a fines and costs case. So I don't think we can set financial bonds on those. So anyways, the court is setting a $250 personal bond. No money is due at this time. And sir, you can, upon your release, close out this file. You can call our collections department at any time and set up a payment plan. If you can't pay it in full, I mean, it's great if you can pay it in full, but we're all at a different financial station in life.
Sure.
And unless the only thing is you want me to set a low cash bond for him, you know, to get credit, or no, I'm not setting a bond.
He should get a personal bond in the
Right.
40.
Yeah. Okay. The bond is $2,500
to guarantee that. Let me say it that way.
Yeah, no, I'm just gonna do what I thought at first. Okay, so let's just recap. The arraignment was held on the bench warrant. Recall and set it aside. He owes $237. We'll set this matter for a show cause at least 10 days out. The Fordham address is a good address. The bond is $250 personal bond, and we will set for a show cause. Do you have, let's give a telephone number for this gentleman.
I did not ask him for one. Sir, do you have a good phone number?
Yes.
Okay, go ahead.
It's 248-747-3631.
Okay, so I'm advising you that upon your release, call the court to either pay this debt or set up a payment plan. Okay, and you are welcome to do that, sir, before the show cause hearing. Okay, and you'll have assigned counsel for that.
Okay.
Anything further counsel requested or required by the court on this case?
No, Your Honor.
All right, thank you so much. This concludes the arraignment. Good luck to you, sir. Thank you, ma'am, for assisting the court this morning. You may both leave the Zoom.
Thank you.
Thanks.
All right, for the benefit of Ashley, let's go to Clayton County, Georgia. Let's go to your home state, and we'll spend a few minutes there to begin to wrap things up.
Give me just one moment.
Oh, this is first appearance court, by the way.
All right, and I have received your application for an attorney, and I find that you do qualify, so I will see that an attorney is appointed to represent you, and that will take care of everything today. Do you have any questions? Okay, all right, thank you, sir.
Can you tell him how much his bond was? Total.
The total bond is, excuse me, hang on just a second. The total bond is $4,000.
4,000. 4,000. Yes. Thank you, Judge.
Okay, thank you. All right, good morning, ma'am. Can you state your name for me?
Tahita Hills.
Miss Hill, all right. Give me just a moment to get your paperwork here.
Yes, sir.
I've been playing this shit the last hour. Came back, whole face. Yo, he like, I can't see. It's way divided. Shit crazy, man.
Okay, Miss Hill, you have two charges. These are both misdemeanors. The first charge is driving on a suspended license. That bond amount is $1,500. The second charge is operating a vehicle without insurance. That bond is $1,000. So your total bond comes to $2,500. The preliminary hearing will be scheduled for June the 3rd at 8:30 a.m. And let me get your attorney application here. All right. Do you want to be represented by a public defender?
Yes, sir.
Okay. Let's grab the wrong one. Hang on just a second here. All right. I find that you do qualify, and so I will see that somebody's appointed to represent you. I also note here that you indicated you served in the U.S. military. Is that correct?
Yes, sir.
What branch did you serve in?
Army.
Army? How long did you serve?
You.
A year? Okay.
Use.
We have a veterans court program. We'll send your information to them, see if there's any other resources that they have that can help you there too. So, okay, that will take care of everything this morning. Thank you, ma'am.
Qualify for the OR bond?
No, ma'am, not on the insurance charge is not one. So the total bond will be $2,500.
Thank you.
Thank you. Excuse me just a second here. All right. And good morning, ma'am. Can you state your name for me? You gotta speak louder.
Eddie Coleman.
Coleman. Okay. All right, Ms. Coleman, you have two charges. The first charge is criminal trespass. That bond is $1,000. Second charge is providing a false name, address, or date of birth to law enforcement. That bond is $1,500. So that makes your total bond $2,500. The bond will have a special condition that you're not to return to Hartsfield-Jackson Airport while out on bond unless you're in possession of a valid ticket for travel on that same day. Your preliminary hearing will be June the 3rd at 8:30 a.m. And I am going to assign an attorney to represent you, and that'll take care of everything this morning. All right. Thank you, ma'am.
You know, take your hands out. Take your hands out. I'll sit right there. I'll sit right there. As you got.
All right. Good morning, ma'am. Can you state your name for me?
Poetry McDonald.
You're going to speak up.
It's Poetry McDonald.
McDonald? Okay, I gotcha. All right. All right, Miss McDonald, you have three charges here. First charge is providing false information to a law enforcement officer. That is a misdemeanor. That bond is $1,500. The second charge is a violation of the Georgia Controlled Substances Act. It's a felony. Based on the information that I was provided, I'm going to dismiss that charge this morning. That is something that can potentially be brought against you again in the future, but I am dismissing it for this morning. The third charge is possession of marijuana less than 1 ounce. That's a misdemeanor. That bond is $1,000. So that leaves you with the two misdemeanors, total bond of $2,500. Your preliminary hearing will be June the 3rd at 8:30 a.m. And give me just a second to get your attorney application. And do you want to be represented by a public defender?
Yes,
Yes. Okay. Are you currently employed?
no,
Okay. All right. I'm going to find that you do qualify, and I will make sure that somebody is appointed to represent you on this case. And that'll take care of everything this morning. Thank you, ma'am.
Harris. Oh, this way.
What's that already?
All right. Good morning, ma'am. Can you state your name for me?
Harris.
Miss Harris, Tahira Harris.
Yes.
So, okay. All right. All right, Miss Harris, you've got two charges. The first is a misdemeanor, it's battery. That bond will be $3,000. The second charge is felony interference with government property. That bond is also going to be $3,000. So your total bond is $6,000. Your bond will include special conditions that while out on bond, you are to stay away from and have no contact with Daryl Spear. If that prevents you from returning to your home, then you can contact the sheriff's office within the first 10 days of your release, and they'll give you a date and time that you would be allowed to go in and get what personal items you need. The preliminary hearing will be scheduled for June the 4th at 8:30 a.m. And do you want to be represented by a public defender?
Yes.
Sorry? Yes? Okay. Are you currently employed?
Yes.
All right. Are you paid weekly at your job?
No.
How often are you paid? Bi-weekly? So when you get your check every other week after taxes are deducted, how much are you left with?
Big plan.
About 600? Okay. All right. I'm going to find that you do qualify for the public defender, and I will see that somebody's appointed to represent you on this case. And that will take care of everything this morning. Thank you, ma'am.
You don't have to sign.
All right, I'm sitting.
That's it, the female side.
Okie dokie. Probably a good time to wrap it up, but a couple of things to cover first. So out of Harris County, for those of you who joined us late, the word is that Judge Fleischer is done live streaming. We'll see if that's really true or not as the days and weeks move on. But supposedly there was a complaint, or several complaints actually, filed against him by a bunch of attorneys. And it looks like he backed off. Now, I'm looking right now at Harris County, and Court at Law 10 and Court at Law 13 are still streaming Juanita Jackson, Raul Rodriguez, and maybe we'll visit them next week. But that's interesting to me. It tells me that it's either there was a complaint against the courts at law in general, and these two are standing their ground, or they were specifically targeting Judge Fleischer. I have no idea. It's not like a whole lot of this stuff is going to become public. Adamisi done live streaming. Do you mean he'll never stream? That is the rumor, yes, that he is not going to live stream anymore. But it's not like anybody's making definitive statements on this. It's just bits of information that have come out supposedly from his staff. So we'll see. But anyways, regardless, the show goes on here. As I said before, I don't focus this channel just on one person, one judge. I want to have kind of a broader thing going anyways. And honestly, this is one of the reasons why. I mean, people come and go. People get on the bench, they leave the bench. And quite honestly, there's something to be said for having a little bit of a diverse pool that we're looking at anyways. So he's stuck like Chuck. Yeah, maybe. So what's the issue with streaming that these attorneys don't like? Lindsay, I don't know. But I can make educated guesses. And I alluded to this when I mentioned it at the beginning of the stream. Right or wrong, it's fact. If you gain too much notoriety, if you stand out too much from the crowd and you have a loud voice, that can tend to get you targeted. You look at kind of his antics and how he's somewhat over the top with things. You look at how he dresses, and you look at the notoriety that got him. And that put him on a lot of people's radar. That's just, again, this is opinion. None of this is fact. It's just what I think. But I think it put him on people's radar. And, you know, you get on people's radar, who, especially if they don't like you, you either cave under the pressure or you put on your armor and you go to battle. And Judge Fleischer has never particularly struck me as somebody who is prepared to go to war on things. Now, again, I don't know the man. I've never met him, so I could be wrong. It's just what I see and what I read. And I've felt for a while that he's been off and that there's something not right. So I think it was getting to him, and it's probably just kind of been pushed over the edge. But we'll see. I'll keep an eye. And if he starts streaming again, of course, we'll cover him. If not, there are so many judges out there. Just yesterday, during the stream, because all of our Michigan judges went away, because they're at that conference, as I was paging through trying to find things to show you, I ran across over 20 different courts that I didn't even know existed. And were streaming. So there's so much out there that we can watch, and so much out there that we can do that I'm honestly just excited to keep moving forward. And to that end, I want to end today with a comment, and then I want to talk about one more thing. So somebody named MD became a channel member a couple of days ago, but I'd never actually seen them in our comments or anything like that, and that's not unusual. We get channel members off of regular videos too. But last night they left this comment on yesterday's live stream. MD says, I can never watch your streams in the morning because I have to work. Lately, it's become my nighttime routine to watch these recordings. I do miss the live chat, though. Also, I'm still laughing at the family violence incident from May 7th stream, where the probable cause statement said that the complainant had not making a sandwich was the reason for the assault, which, if you recall, that was it. And I think ketchup was involved, too. Or was that a different case? There was some crazy going on. It's terrible, but, you know, law enforcement made damn sure they included that bit in their report. Yes, they did. And then MD says, P.S. I know you're trying to grow right now, but I really like the small channel feel. Unfortunately, when they grow, court watch, true crime, and law enforcement focused channels tend to attract a crowd that's more reactionary, less interested in how courts work, and they can be very toxic, political, racist, off topic, etc. I thoroughly enjoy your content, commentary, and community as it is. I really hope it stays like this, even if it grows. Lindsay, thank you for becoming a channel member, just like that. That's very much appreciated. Just so you know, Lindsay, every dollar that comes in through channel memberships goes right back into the show to making it better. I don't pocket that money. We put it right back into the show. So welcome, it's appreciated. And everybody, please thank Lindsay in the chat for becoming a channel member. So, anyways, I want to say that I agree with MD about the idea of keeping this a focused space and having that small channel feel. That is, if you haven't figured it out, it's part of what I try to do here. I'm not interested in the over-the-top drama and the frankly BS that just comes with so many other channels. I mean, there's always a little bit of that because it's part of the human nature of what we watch. There's always going to be a little bit of drama. There's always going to be funny moments, sad moments, all of those things, and that's all okay. But I don't ever want that to be the primary focus of what we do. We can watch it, we can talk about it and whatnot, but the reason that this exists, in my mind anyways, is for us to come together and learn and grow and get more familiar with our judicial system. It's an important part of our governance, and too many people don't understand it. And if you don't believe me, pick any video on the channel, go read through the comments and see all of the people who comment that really don't understand how all of this stuff works. So that's where I'm trying to make the difference. But I also real quick want to explain why I'm doing this so you understand a little bit of my motivations, because I've said before, I think it's important that you understand who I am and what I'm trying to do and all of that. I've talked to you before about how this channel started. I mentioned that a couple of times, so I've not necessarily mentioned the why. And the why is a couple of reasons. First, I'm having the time of my life, so I'm going to keep doing it just for that reason alone. But we've been in Arizona for a long, long time now, and one of our longer-term goals is that we want to go elsewhere. We want to have a large piece of property. I enjoy working with animals. I want to do a little bit of a hobby farm kind of situation. We grow a lot of our own greens and stuff here. I want to be able to do that on a larger scale. And I want to live a quieter, more self-sustaining life. Still work hard like I do, but I want that peace, and so does my wife. So we sat down last September and we talked about a roadmap of how to get to where we want to go. So we need to hit this goal at this point and this goal at this point and all of that kind of stuff. But the question came up, well, how do we get the money to get there? What do we do? And I said, we keep our eyes open. And when opportunities present themselves, because the Lord will present those opportunities, we're not so blind that we don't see them, and we take them and we run. And a few weeks later, what happened, it goes back to the story of how we started this channel. This idea was presented in front of me, and I took it, and it took off. And sadly, in December, my wife's father, who we spent a lot of time taking care of because he needed 24/7 care, passed away. I'm very sad that he passed away, but in the same respect, when that happened, it kind of cleared a little bit of a path, and then we started doing this live show. And the long story short, I feel like this is the path that has been put in front of me to get to where we want to go. And the bonus of it is it's a very enjoyable path, and I love interacting with all of you. And we've actually made strategic decisions to take a little bit away from some of our other businesses that we run and put that time and that effort into this, because we believe this is the future. But part of that future is I'm not going to let it devolve into what everybody else is doing. I'm a big believer when you do something, you need to make it unique. You need to make it different. If you do what everybody else does, it just falls into that muck. You don't stand out. Those who are successful stand out. So while I'm treating this like a family, I'm also treating it like a business. And I think in the end that benefits you, my extended family, if you will, because it means I'm taking it seriously and I'm going to treat it right, and I'm going to do what we need to do to move forward positively. So I just wanted to share that, and I hope it all makes sense to you. But I never really said the why, and this is very much the why. Y'all know I'm a man of faith, and I I feel very much that God put this in front of me, not only as our path to get to where we want to go, but to, quite frankly, make a difference. And I don't expect it to be a world-changing difference, but at one point there was 40-some people on the stream today. If those 40-some people learned a little bit, well, that's making a difference. So it's a win-win for everybody, and that's what we're trying to do here. So, thank you all for your comments. Kazman, may the Lord continue to bless you. Thank you. May the Lord bless you as well. Bailey says you're a great host. Thank you for that. Vicky, I enjoy that you do the hoping for me, or the hopping, I think you meant. Just listen and worry. And not opinionated and loud. Yeah, I try not to be. Look, I'm not going to be afraid to tell you what I think, but, my opinion shouldn't step on everybody else's either. Discussion is how we learn. All right, well, I appreciate everybody's kind words. I really do, but you don't need to listen to me yammer on anymore today. So go on about your weekend. Have a good day today. Have a good weekend. We'll be back Monday, 10 a.m. Eastern, 7 a.m. Pacific. Channel members, please do keep an eye on your membership over the weekend. I put out that poll about possibly doing a pre-show. That is something that I want to try. I'm going to attempt to have it ready for Monday. I don't know if I can or not, though. If I can, there'll be a comment posted for members so you'll be able to see that that's coming up and instructions on how to do it or whatnot. So keep an eye out, but no promises. But coming soon, if not Monday. Anyways, that will be that. Like I said, go have yourself a great weekend. Take care and God bless.